I think the importance of the Cadbury papers derives from the importance of the Cadbury report. The Cadbury Code, which was first articulated in 1992, has since been adapted and adopted in 100 countries around the world, which means that it's not only people or researchers in the UK who would be interested in the process which led up to the report, but also governance researchers around the world. The Cadbury Archive includes all the records based on submissions to the committee, the agendas, the minutes, the appeals, the disagreements, responses to the initial draft, and the final report, of course. So for anyone wanting to understand the process through which they arrived at consensus, it's a very interesting archive. It underscores the point that corporate governance research is very important at Cambridge. In fact, I like to say that an interest in corporate governance issues predates the use of the word corporate governance. You can go back to the work of Pigot, who talked about externalities, the fact that people unrelated to a transaction could face costs from that transaction. You could talk about John Maynard Keynes, who talked about the modern joint stock company and the divorce between ownership and management. You can talk about Robin Maris, who died a few months ago at the age of 88, who had a lot to say about managerial capitalism in the early 60s and the role of takeovers in possibly, or possibly not, controlling managers. So I think the Cadbury Archive underscores the point that corporate governance research and issues related to that have been very important to Cambridge. And the new Cambridge Corporate Governance Network, which brings together researchers in the law faculty, the Judge Business School, the Center for Corporate Law, and also from economics, is a great addition to our portfolio because it allows us to showcase the work which is done across the university. The Cadbury Archive is an integral part of that. It's very difficult for us to say what life might have been without the Cadbury Code and its descendants. So that's one possible response. You could also say that some of the reasons for the current crisis might not directly relate to the issues that were tackled in the Cadbury Code itself. The Cadbury Code focused on the separation between chairmanship of the board and management of the company. To some extent, that has not been the focal point in the current crisis. The Cadbury Code also focused on the independence of directors, the importance of that. Yes, that has come up to some extent, but I suppose we are reminded now that it's not only independence that matters. There was a word in the Cadbury Code, the original one, about the caliber of independent directors. And I think we are reminded now that independence alone may not be sufficient. We need people of the right caliber who know enough about the industry, who have sufficient time to engage in the businesses that they are looking after, and have sufficient passion in that industry as well. One of the problems in the current crisis is that we've learned that there are risks undertaken by corporations which even the management don't understand. And that's one of the challenges of corporate governance, how we make sure that the board understands fully what each of the subdivisions is up to. The Cadbury Code is still in the news. It was just 10 days ago, or thereabouts, when there was a vote at JP Morgan where shareholders were voting on whether the roles of chairman and chief executive should be separated. Currently, the incumbent, Jamie Dimon, holds both. And the vote actually went in favor of Jamie Dimon holding both roles. And in that context and in the discussion in the press, the Cadbury Code was discussed very much. So the Cadbury Code isn't a forgotten piece in corporate governance. It's still very much discussed. And I don't think it is the fault of the Cadbury Code that we have a current crisis. In the United States, there are some organizations like Citigroup that have separated the roles of chief executive and chairman. On the other hand, JP Morgan and Wells Fargo haven't. Is it a shame? Well, you could argue that the original Cadbury Code talked about the possibility of a lead director who might play the role of a foil in case an individual held both the roles of chairman and chief executive. In fact, that argument has been invoked in the JPM discussions. And people have argued that a lead director may be acting on the board in that way. Now, whether the person is sufficiently independent and powerful from the outside, we cannot really say at this point.